Okay, aloha everyone. My name is Elena Hafine and I'm the moderator for this morning's session titled Clean Water Act Violation Case Studies. Please use the Q&A feature during the presentation to ask any questions you may have. At the end of the presentation, we'll have a few minutes for the speakers to answer your questions. So without further ado, I'd like to introduce our speaker for this session. Naomi Kuwaye is of counsel at Ashford and Riston. She practices in the areas of environmental and natural resources law, land use, real estate development, telecommunications law, and administrative law. Her practice includes environmental litigation and regulatory compliance with federal and state law and regulations, including the Hawaii Environmental Response Law, the Hawaii Environmental Policy Act, Clean Water Act, and the Endangered Species Act, as well as representing clients before various boards and commissions on land use matters. Please help me in welcoming Naomi Kuwaye. Good morning, Naomi.
Good morning, Elena.
Go ahead and share your screen.
Is that showing up, Elena?
Yep, looks good.
Okay. Good morning, everyone. My name is Naomi Kuwaye, and I was asked to give an overview on Clean Water Act and the legal perspectives, and just some overview on what to expect from an enforcement standpoint. Before we get there, I want to give a brief background of the Clean Water Act and examine how we got here today. It all started with the Rivers and Harbors Act in 1899. Congress adopted it primarily to protect navigation and prohibit discharges that would interfere with rivers as transportation links. This was at the height of the Industrial Revolution, and the U.S. waterways were beginning to serve an integral part for commerce and transporting goods to various cities around the states. Factories were being built along the waterways for easy access to harbors. Consequently, sediment, trash, and other minerals began to pose a problem for ships to easily navigate the U.S. waterways. In 1948, Congress was not quite happy with the existing confines of the Rivers and Harbors Act, and Congress gave regulatory authority to the federal government through the Federal Water Pollution Control Act. While states still had general control over said waterways, Congress wanted more consistent laws. In 1956, the Federal Water Pollution Control Act was amended to provide states and local governments with funds to construct wastewater treatment plants and to grant the federal government more authority to step in where there were serious water problems across state lines. There was an increasing realization that reliance on consensus and voluntary compliance was rendering the act ineffective. In 1961, Congress amended the act to broaden the federal government's enforcement powers and to increase federal support of state and interstate pollution control. In 1965, the Water Quality Act was adopted, ordering states to develop water quality standards subject to federal review and to come up with plans to meet them. The law is significant in that it began to focus on the ecological health of waterways for fishing and swimming versus historically on just drinking water and human health. In 1972, Congress amended the Federal Water Pollution Control Act and passed what is now known as the Clean Water Act. The goal of the Clean Water Act was to eliminate pollution in all navigable waterways of the United States by 1985, established a federal discharge permit system, provided for broader federal role in setting effluent limitations, increased funding for sewage treatment plants, and expands on the federal government's role and in oversight and enforcement. Significantly, the premise of the Clean Water Act was to prohibit discharge of pollutants into the waters of the United States. There are 4 key provisions that you should be aware of. the Section 402 program, which created the MPDS program, Section 44, which was the dredge and fill material permits program, Section 505, the citizen suit for violations program, and Section 309, which allows EPA to enforce permit conditions and fines. Again, the 1972 amendments were significant. It established a basic structure for regulating pollutant discharges, what we are familiar with today. It gave EPA the broad authority to implement pollutant control programs, such as setting wastewater standards by industry. It maintained existing requirements to set water quality standards for all contaminants in surface waters, made it unlawful for any person to discharge any pollutant from point sources into navigable waters unless a permit was obtained under its provisions. And it should be noted that that particular provision is the most litigated provision in the past 5 to 10 years. And I'll be discussing a couple cases that focus on that particular provision. In addition, it funded construction of sewage treatment plants under the construction grants program, recognized the need for planning to address critical problems posed by non-point source pollution. And again, it created citizen suits, recognized that citizens now had standing to challenge the implementation of environmental protection laws. The MPDS program is established is based on the express statutory authority in Section 402 of the Clean Water Act, but its historical origins go back to the 1899 Refuse Act prohibition against all industrial discharges to navigable waters. In general, the permitting authority may issue a permit for the discharge of any pollutant or combination of pollutants notwithstanding Section 301A. The MPDS permit contains effluent limits and must meet uniform national technological base requirements as outlined in Section 301, subsection B. In certain instances, you're required to meet water quality-based effluent limits. So what does this mean? By placing limits on the pollutants that may be discharged via a permit system, the permits protects the discharges through what we refer to as a permit shield. As long as you comply with your permit issued by the government, you are deemed in compliance for purposes of enforcement. So what are the consequences of the Clean Water Act violations? So it's strict liability for violations, and violators' intent and good faith are irrelevant to the liability issue. And the fact that a violator is without fault in committing violations of the Clean Water Act may mitigate the amount of the penalties assessed. However, it will not absolve the violator from penalties. And these cases that I cited here are good examples where the permittee thought that they were acting in compliance with their permit without actually having looked at their permit. There were discharges that were not consistent with their permit, and they were subsequently sued because of violations. In both cases, there were some mitigating standards. In the city and county case, the city and county actually had conferred with the Department of Health and thought that the subsequent regulations that the Department of Health had implemented would supersede its permit requirements. It did not. And as a consequence, there were a number of discharges that were not permitted by its permit, and a lawsuit was brought by Hawaii 1,000 Friends. When they took a close examination of the permit, the court agreed that the city and county of Honolulu was in violation with their permit, regardless of their belief and their intent to comply with the permit itself. They were not. It was, in fact, prohibited under the permit for conducting certain releases. The court looked at it and said, yeah, you are liable for those releases and you're in violation. However, the court looked at mitigating circumstances, the fact that they were conferring with the Department of Health at the time, and they thought that the Department of Health's regulations, which were a little bit more stringent, allowed them to supersede their permits requirements. Based on all of that, the court said, okay, you're in violation, but we're going to go ahead and still fine you. The fines were hefty, but not as hefty as if they had done it, I guess, just blatantly without any regard for the laws. If the Clean Water Act or relevant state laws require a permit for discharge activities, you must obtain a permit and comply with the requirements. That was one thing that the three other cases pointed out. If you create a conduit for pollutants for which a permit is required but had not obtained one before the creation, the creator will be in violation of the Clean Water Act until a permit is obtained, regardless of whether its discharge activities conform to the technical permit requirements. Again, once Clean Water Act violations are found, civil penalties are mandatory, although the amount of the penalties are discretionary to the courts. First-time violators can be punished by a fine of between $2,500 to $25,000 per day per violation, and in most egregious circumstances, the violators could face imprisonment. So these are the kind of the relevant cases that kind of affect the NPDES program and Clean Water Act analysis that attorneys go through. The first question that we always ask ourselves is, when is the NPDES required? And I think everyone is familiar with the County of Maui versus Hawaii Wildlife Fund case that the Supreme Court recently issued its decision in April of 2020. And in that case, the Supreme Court said that, well, let me get back to some background issues. There were some injection wells that were operated by the county. They were operating a wastewater treatment plant, and they were depositing the effluent 200 feet underground into the groundwater aquifer beneath the facility. The effluent pumped into two of the injection wells eventually found its way into the Pacific Ocean through underground groundwater conduits, and the county was aware of this. At dispute was whether or not the groundwater conduits was in fact a point source pollution, and whether or not NPDES permit was required by the county in order to make those discharges. The Supreme Court held, and it basically overturned the Ninth Circuit's analysis, but found that there was in fact a Clean Water Act violation. And the court held that the Clean Water Act requires a permit not only when there is a direct discharge, but also where there is a functional equivalent of a direct discharge. The court rejected the Ninth Circuit's fairly traceable test, as it would have allowed the EPA to assert permitting authority over the release of pollutants that reached navigable waters many years after release, and the court found that was not the intent. But where the timing between the release in the present case to it showing up into the ocean was relatively short, and the court held that that was a functional equivalent of a direct discharge. The next question that we ask ourselves as attorneys when we're examining a question is, what constitutes knowingly discharge when it comes to an NPDES or Clean Water Act violation? In the U.S. versus Weishoff case, Weishoff was a manager and Mariani was assistant manager of the East Honolulu Community Services sewage plant on Oahu. They oversaw a sewage plant treatment process of removal of large inorganic items from incoming wastewater as it flowed through metal screens and a grit chamber. The wastewater entered large tanks where a portion of the organic solids settled to the bottom of the tanks. The solid material which settled, known as primary sludge, was then pumped into separate tanks known as anaerobic digesters to be further processed. These solids did not settle and continued to aeration basins. The sludge that had settled in the final clarifiers was pumped from the bottom. Some of that returned to aeration basins, while the remainder, known as waste activated sludge, was pumped into holding tanks to either receive additional treatment or to be hauled away. There was evidence that some of the sludge was discharged directly into the oceans, and employees testified that Weishoff instructed them not to say anything about the discharges that was regularly occurring at night, but was not reported to the Department of Health or to the EPA. Mariani denied any connection between the plant operations and the discharge. There was an FBI investigation, and Weishoff and Mariani were charged with 31 violations of the Clean Water Act and conspiracy to violate said act, and they were sentenced to jail. So the issue that was presented to the court was, do you have to know that you are violating the terms of the Clean Water Act permit? The lower court held that defendants knew they were discharging pollutants into the ocean. This met the intent requirement. It was not necessary to know that you were violating your permit itself. On appeal, the appeals court agreed. The Clean Water Act was a public welfare offense that placed a more stringent requirement on persons acting in violation of the public welfare law. Therefore, it was not necessary that the defendants knew that they were violating law. It was enough that the defendants had authorized the discharges. The next case is the question that we ask ourselves is, what constitutes a person? In U.S. v. Curtis, Curtis, a fuel division's director, directed his subordinates to pump jet fuel through a pipeline connecting the main storage tanks to the stream and electrical generating plants, knowing at the time that the pumping would cause jet fuel to leak from an abandoned spur line. Those actions ultimately caused jet fuel to leak into an intermittent stream that found its way to a creek and into the Bering Sea. At issue was, and defendants argued, that he was not a person subject to the enforcement provisions of the Clean Water Act because he was a federal employee whose alleged violations occurred during the course of his federal employment. The Ninth Circuit disagreed and held that individual government employees are not immune from prosecution for their criminal acts. And the plain meaning of individual without express intent from Congress did not exempt government employees from this definition. So it basically held that the federal shield for individuals or employees of the federal government did not apply. So limitations of the NPDES permit shield are present. While their NPDES permits do provide shields from basically discharges or pollutants discharge of pollutants into U.S. waters, there are limitations on the permit shield as addressed in the Piney Run Association case. Their Piney Run Association brought a lawsuit claiming the county had violated the Clean Water Act by authorizing discharges of heat, which was not specifically listed in the permit. The county argued that they adequately disclosed that the plant was discharging heat. The court held that the commissioners did not violate the Clean Water Act because they complied with the discharge limitations and reporting requirements of their permits, and the discharges of heat were within the reasonable contemplation of the permitting authority at the time of the permit was issued. In other words, because in their application they disclosed that there was going to be heat discharges, they were absolved from any violations of their NPDES permit and the Clean Water Act. And they found that the commissioners adequately disclosed such discharges. So what are the waters of the United States? There's all these cases dealt with what constitutes discharges into the waters of the United States. And this is actually about 10 to 20 years ago. This was a heavily disputed matter for the courts. In Rapanos, the federal government brought enforcement action alleging developers and their wholly owned companies illegally discharged fill material into protected wetlands in violation of the Clean Water Act. And at issue was whether wetlands lying near ditches and man-made drains that eventually emptied into the traditional navigable waters considered navigable waters for purposes of the Clean Water Act. The court held that the term navigable waters includes only relatively permanent standing or flowing bodies of water and not intermittent or ephemeral flows of water, and only those wetlands with continuous surface connection to bodies that are waters of the United States in their own right are adjacent to such waters and are covered under the Clean Waters Act. A wetland may not be considered adjacent to or remote waters of the United States based on a mere hydrological connection. In other words, isolated ponds are not waters of the United States in their own right. Only wetlands with a continuous surface connection to bodies are waters of the United States. Recently, there have been some changes to the Clean Water Act and the NPDES program during the Trump administration. And when I met with the DOJ and the EPA last year regarding what their focus has been during the Trump era, these are some of the things that they reported to me. So in 2019, the EPA reported that they plan to return to their core program in collaboration with authorized state programs. And the EPA proposed to transition from keeping industrial pollutants out of the nation's waters to a national pollutant discharge elimination system significant non-compliance reduction program. What does this mean? It basically, according to the EPA, their focus is now on increasing the percentage of permittees in compliance rather than taking a hard violation approach. They want to keep everyone in compliance. So what they did was they wanted to go to a self-disclosure audit policy. This poses nothing new or significant for existing permit holders, but for new holders, the new owner audit policy offers expanded coverage for violations that might not otherwise qualify for penalty mitigation under the Clean Water Act. NPDES discharge violations disclosed to the EPA prior to the regulated entity's first instance of monitoring, sampling, or auditing are covered. Finally, in March 2020, the Department of Justice ended its longstanding practice of allowing the inclusion of environmentally beneficial projects in legal settlements with the EPA to offset environmental harm caused by defendants. So what that meant was that DOJ no longer encouraged basically beneficial environmental projects to offset the environmental harm caused by contamination. Um, what the environmental groups reported back to me was that makes it more difficult for settlement to institute basically offsets, project offsets that would um, um, mitigate the project's environmental contamination issues. And it focused more on imposition of fines and penalties rather than beneficial projects. Next, I'm going to go over some recent case developments that were occurring around the United States. Some consent decrees that I thought should be noted and might be informational to the attendees here. The first one is the city of Middleton in Ohio. In February 2018, the EPA entered into a consent decree with the city concerning the discharge of sewage into local waterways in violation of the Clean Water Act. The settlement required the implementation of long-term control plans with control measures to reduce the discharge of pollutants by over 300,000 pounds per year. And again, this goes to the EPA's focus on increasing the percentage of permittees in compliance and making sure that the violators had a plan in place to address and reduce pollutants being discharged. And the next case is the city of Quincy, Massachusetts. In March 2019, EPA filed a civil judicial complaint against the city for the discharge of sewage and untreated wastewater into Boston Harbor, Dorchester Bay, and Quincy Bay, and other waterways from the city's sanitary sewer and storm drain systems. And my understanding is that this case is still ongoing, but again, they are looking at a combination of civil fines and a long-term plan with control measures to stop some of the discharges that were occurring by the city of Quincy. Next case is Evangeline Enterprises LLC. In October 2018, EPA entered into a consent decree with Evangeline for unauthorized discharges into the waters of the United States in violation of Section 301 of the Clean Water Act from a horse training facility in Louisiana, which qualified as a concentrated animal feeding operation. Rather than coming up with a comprehensive plan that would have cost the company a substantial amount of funds to comply with, Evangeline eventually closes the operation and paid a $30,000 civil penalty. Next is Antero Resources Corporation. In 2019, the EPA entered into a consent decree for violations of sections 301 and 404 of the Clean Water Act for discharges of dredged fill material into wetlands and streams in connection with a natural gas exploration and production activities at 32 sites. The decree required restoration, enhancement, creation, and preservation of over 11,500 linear feet of streams and more than 3 acres of wetlands, and it was valued at $8 million. Additionally, a $3.15 million civil penalty was imposed because of the amount of the contamination. So some of the lessons learned from the cases that I just reviewed are violations of the Clean Water Act is a strict liability. If you violate it, regardless of your knowledge of your permit or of the law itself, or your intent, whether or not it was good or bad, if you violated the Clean Water Act, you're strictly liable and you'll be found in violation. The MPDS is a permit shield. but you must operate within the confines of your permit. Failure to know what your permit allows or doesn't allow equals a violation, and the courts have no discretion as to finding a violation has occurred. Violations can be expensive. Restoration fines may no longer be part of a settlement package. However, that may change under the Biden administration. Settlements now generally require an acceptable plan to rectify the problem that is existing, as well as to address future violations of any possible discharges. And you have to come up with that, and that could cost several $1,000,000 as well. In addition, you will not get away from civil penalty provisions. There might be mitigating factors, but courts will issue a civil penalty, and so will the EPA. So that's kind of where we're at right now on the legal updates to the NPDES and Clean Water Act program. I'm happy to answer any questions that you may have.
Thank you, Naomi, for your presentation. We're now going to open up the question and answer portion of the session. So if anyone has any questions for Naomi, please type them in the Q&A section at this time. We have one question so far. So this question is from Anonymous. We will be replacing a gate valve in a water line. Per contract, we'll be providing a temp watertight spill containment to collect leaking water, pump to vac truck. Vac truck will be using this water for future hydro demolition operations. The question is, do we need an NPDES permit?
Will be replaced. Okay. Replacing a gate valve. Per contract, we will be providing a temporary watertight spill containment. I don't know enough about I guess, what is involved in order to determine whether or not an NPDES permit would be triggered here. I would need to probably take a look at more of what is involved, where this is located in order to assess whether or not an NPDES permit is required. However, if there's any possibility that water will be going into the sewer systems at all or reaching offshore waters, then yes, you will probably need an NPDES permit. Located in a, yes, then probably.
Awesome. We had one other question come in through the chat function. This is from Alex Vandewater. Are the violation fees ever settled for a smaller amount, or is the violator always liable for the full amount of the fine?
Well, there's a range between $2,500 to $25,000 per day. I think it depends on the circumstance. If it's really egregious, you will be fined a $25,000 per day per violation. If it's just oops, I made a mistake, it will probably be on the lower end. And the court has discretion as to what those fines will be. I don't generally see it except in really egregious circumstances where it's in the millions of dollars. Most times I see it within the 10 to a couple $100,000 range, depending on the circumstance.
Great. We got another question in. Daly says, thank you very much. My question is, how many fines were directly related to hydrocarbons for the last 2 years?
I have no idea. I haven't looked at, I haven't examined that.
All right. Next question from Anonymous. Under NPDES Form C, is the permittee required to comply with water quality testing if the project is subject to the state bridge bill exemptions?
I'm not going to speak for the DOH, but I would think that yes, you would have to comply with the water quality requirements. And I'm looking at it from the federal standpoint. When I talked to the EPA people last year, really they were focusing on the water quality requirements and the levels. But I understand that DOH has certain requirements, and so I would actually confer with the Department of Health as to is that something that they would require. I can only speak to what EPA would be looking at.
Okay. Bailey wants to know if, in regards to his question of how many fines were directly related to hydrocarbons in the last 2 years, if you have an estimate.
No,
Again.
I don't. I don't.
Okay.
Sorry, I don't. I haven't even looked at that issue recently. And I, just so you know, some of the cases that I came across, I didn't see any hydrocarbon um, cases that popped up on my radar, but that doesn't mean that there isn't any out there. I mean, the EPA and issues and DOJ enter into these type of enforcement actions around the country, and the ones that were brought to my attention are the ones that they thought I would be interested in. And that was only 4 of, I think, 50 that they sent over to me. So that occurred in the past 3 years.
Okay. And we have one more question from Anonymous. Since 1972, a federal Clean Act, Federal Water Clean Act, FWCA, not familiar, amended Now Clean Water Act. Is there a violator fined from 25,000 to 2,500 to 25,000 per day for each violation, and/or imprisonment up to 1 year since the violation occurred? The sentence wasn't complete. If so, do we have a standard operating procedure enforcement to follow? So let me read this again. Since 1972, Federal Waters Act was amended, Now Clean Water Act. Is there a violator fined from 2,500 to 25,000 a day for each violation, and/or imprisonment up to 1 year? If so, do we have a SOP, standard operating procedure, or enforcement to follow?
Okay. Okay. I think the question is, since the Clean Water Act implemented these fines and the imprisonment provisions, is there some type of guidelines that the courts or the EPA utilizes in as far as when to I guess charge certain fines versus imprisonment? From the cases, there is no standard operating procedure that I am aware of that the courts have looked at. And the EPA or the Department of Justice probably does have something, but what I've been told is that it changes from administration to administration, and it really depends on the unique circumstances of the case. So some of the earlier cases that occurred in Hawaii that I discussed during my presentation, those were really egregious circumstances, which is why those employees faced imprisonment. Basically, they tried to hide the fact that they were violating the Clean Water Act and were not operating within the confines of their permit. Then there were other cases where the county just didn't know that their permit required certain actions, and they were conferring with the regulatory authority. They thought everything was good when in fact it was inconsistent with their permit. In that case, the fines were very minimal and no one faced any type of criminal action. So those are the type of things that the court is going to be looking at, and I think the enforcement authorities would be looking at. One is, was it egregious? Did you just you knew you were violating it and you tried to hide it, which is what was described in a lot of the cases where jail time was involved, versus I didn't know, I conferred with the regulatory authorities immediately. They advised me to do this. I thought I was operating within the confines of my permit. Oops. And in that case, the fines were very minimal considering the amount of discharges that occurred. I hope that answers the question.
Thank you. And one more question. With regards to the imprisonment provision in the Clean Water Act, who actually would be the one to go to jail? Would it be the person who pulled the permit or the owners of the company?
Generally the operators. And it's usually I'm going to say it's the operators, unless it was the owners that basically tried to hide the information. So anyone who tried to hide the information, not just or directed that the violation occur, those are the ones that are probably going to face criminal action. I think the courts will be looking at those people versus if the owner kind of relied on the operator, to maintain the facility in compliance, and the operator was basically knew that they were violating the law and ordered certain things to occur, that person will probably face imprisonment. If the owner directed the operator to violate the law, and both of them will probably face imprisonment.
Thank you. Don't have any more questions at this time. We'll give it a little bit longer in case anyone has any. Oh, we got one in. So if groundwater is contaminated but does not reach the ocean, is this a violation?
You might be in trouble with the Department of Health because the Department of Health has strict guidelines regarding what goes into their groundwater. So yeah, I would definitely, I'm not going to speak for the EPA. You will be in violation of basically a Safe Drinking Water Act, probably.
No other questions at this time. Give it one more minute. We're a little early, so in case anyone has any follow-up questions.
Advice.
We got a thank you, very informative. Great. So we'll go ahead and close. So thank you again, Naomi.
Thank you.
Now concludes this session. Thank you everyone for attending. The next sessions begin at 10 a.m. So please return to the sessions tab to see the next breakout sessions. And if you're experiencing any technical issues, please visit the info desk for assistance. Also, don't forget to stop by and check out the vendors during the break. Thank you, everyone. Thank you, Naomi.